Good afternoon and welcome to Legal Lunch with Laura. I'm glad you could join us for this 1 hour of information-packed seminar on the topic of wage and hour laws. I just wanted to give a brief warning that our internet connection has been a little faulty this morning. So we are recording this simultaneously. So if we lose you, try to log back on. And if you are unable to log back on, this will be recorded and up on the Afik Herman website for you to download, and it will not affect your ability to receive HRCI credits for continuing education for your human resources certification. Before we get started, I wanted to talk about future lunch dates that we have planned. The next one is Tuesday, May 21st, on the topic of benefits of a workplace mediation program. Webinars are held on the third Tuesday of every other month at lunchtime from 12 to 1. If you have any interest in hearing about any other topics, please feel free to email me at any time. And while I mention that, please feel free to write in with any questions that may arise during this broadcast. In the bottom right-hand corner, just type your question in, and if we have enough time, we will get to it. So the topic we have today is, should I pay my employee for that? Navigating the Fair Labor Standards Act. I wanted to, before we get started, I wanted to introduce you to my colleague here at Afik Herman, who is co-presenting this with me today. Good afternoon, Russell.
Hello.
So I wanted to introduce Russell Berger. Russell Berger is a rising star amongst all lawyers. You should know that. He was named as a 2012 and 2013 Rising Star by the magazine Super Lawyers. And Russell is in the Labor and Employment Department here at the law firm of Afik Herman. He works here in the Baltimore office, and he has a broad range of experience in dealing with all types of, as you can see, all those acronyms addressing employment law issues. The Fair Labor Standards Act, which really, as he lists in the first bullet point here, is really Russell's specialty. He is very experienced in defending class action and collective action wage and hour cases, which I've asked him to present today, some cases he's working on and also the other experiences he's had in his past. Russell also handles issues involving the Family Medical Leave Act, age discrimination, workplace discrimination, wrongful terminations, general contract claims, etc. Russell is a graduate of the University of Maryland School of Law, and also I think you played baseball at Hopkins as an undergrad.
I did.
I have that correct.
But I am retired now.
He's retired. Okay. So you know how sometimes people look like someone famous? When asked, Russell said that he thinks he looks like Ryan Gosling. You know, Russell had a wager here at the firm with another colleague when the Ravens were in the running for the Super Bowl, and he decided that he would grow a playoff beard. So this is what Russell, you know, thought he kind of looked like. This is Ryan Gosling with a beard, and you know, I guess Russell would look in the mirror and see this picture. However, when his colleagues kind of looked at him, and we all thought this is what he looked like when he came here to work. So thankfully, growing the beard and having that Neanderthal look worked for the Ravens, and we are all happy that he is since now clean shaven and well groomed. So.
I'd do it again for another Super Bowl championship.
Okay. All right. So on to serious topics. Here are really the objectives for what we plan to cover today. We'll talk briefly about the Fair Labor Standards Act. And then we'll go into appropriate and inappropriate exemptions under the Fair Labor Standards Act. And then we have 4 questions for you in which we'll ask you to interact with us. We will launch 4 different polls and ask you, should you pay your employees for that? Next, we will talk about the difference between independent contractors and employees. A lot of companies make mistakes and they misclassify independent contractors as employees. They mostly see themselves getting in trouble when the unemployment office comes to call, when the IRS comes to call, or another agency comes to call, and their audits reveal that perhaps these independent contractors should have been paid as employees and should have been classified as employees. And then finally, Russell will go into, in some depth, wage class action claims, why they're on the rise, and whether you might be a target. So I think we have a lot to talk about today. And let's get started. So let me give you a brief overview of the Fair Labor Standards Act. It's a broad law, but it establishes what the minimum wage is. It dictates when overtime pay should be provided to employees. It gives a basic understanding to employees and employers of the record-keeping requirement. And then, of course, it governs youth employment standards in affecting all employees in federal, state, and local governments, as well as the private sector. So the FLSA talks about what minimum wage is. And right now, federal minimum wage is $7.25 per hour, and that was changed in July of 2009. There is always legislation in various states and also in the federal government to increase that minimum wage, but currently it is still only $7.25 an hour. Other states have higher minimum wages. Maryland follows the federal law and is only $7.25 an hour, as does many surrounding states in the Mid-Atlantic. So Pennsylvania, New Jersey, Delaware, North Carolina, South Carolina, all are $7.25 an hour. California, as will come up probably from time to time today, is almost its own country. They have unique employee-friendly labor and employment laws, but one of which is that they have a higher minimum wage of $8 an hour. DC's minimum wage is $8.25 an hour, and the highest minimum wage of all U.S. states is Washington, coming in at $9.19 an hour. If you are a government contractor, you know that minimum wage may not be applicable to your employees. Many government contracts are governed by either the Service Contract Act or the Davis-Bacon Act, and under those federal laws, those federal acts, the contract and the type of work being performed governs what employees are paid. It also often dictates that the wage include benefits for employees. And finally, the third bullet point here on the slide is about overtime. Overtime pay is required after 40 hours of work in a single work week at the rate of 1.5 times the employee's regular rate of pay. Many of you might be rolling your eyes thinking, oh, I know that it's so obvious, but many companies make this mistake. Many companies think that, well, I'll pay overtime after 80 hours, or they look at a pay period of a 2-week pay period as opposed to a single work week. And that's when they tend to get themselves in a lot of trouble, when they're not calculating overtime properly. The FLSA also has, very limited protections for employees. So, for example, the FLSA doesn't dictate that employees get paid vacation pay, holiday pay, severance, sick pay. It doesn't, despite a lot of misunderstandings, there is no requirement that employees get paid for meals or rest periods under the FLSA. It doesn't dictate that employees get paid double time for weekend work or holiday work. It doesn't dictate that every year employees will get pay raises or that they're entitled to benefits, although the Affordable Care Act is changing that. And that's not effective until January 2014. and it doesn't indicate when discharges are required.
And Laura, I would just note with respect to the meal and rest periods, certain state laws, many of the states have laws that are similar to the FLSA. They may have different requirements in that respect. In particular, California has very specific rules about when employees are supposed to have a break and how those breaks are compensated and how long they can be. In addition, in the FLSA, generally, I just wanted to make clear that certain rest periods may be compensable, and so it's not, the FLSA doesn't provide a requirement for rest periods, but it may require that certain rest periods, if they're not too long, are compensated. So, for example, if someone goes outside and smokes a cigarette and comes back 10 minutes later, that's probably going to be a compensable rest period, even though they weren't working per se during that 10-minute break.
That's a very good point. And the rule of thumb generally is if an employee is taking a break that lasts between about 15 and 20 minutes, it is considered paid time. Obviously, employees use the restroom, and some employees take smoke breaks. Some employees might have to have a meal break because of a certain disability. And Russell's right, and I think that's a good point that he makes. Most breaks, if they are short in duration, are compensable. One important question that we often get is whether to pay an employee a salary because we want to assume they're exempt from overtime, or an hourly rate. A few clients have asked, well, what's wrong with paying a salary to everyone? I have several new clients who have called and said, well, we pay everyone a salary. Is that okay? Everyone from the front desk receptionist who greets you at the door to the CEO and the CFO. And that can be a problem. The FLSA permits only certain employees to be paid a salary, and I'll let Russell explain this slide about the various exemptions that the FLSA looks at and permits employees to be paid a salary, meaning permits them to be paid and to be exempt from overtime.
Sure. One of the first decisions that an employer needs to make when they hire a new employee or when they create a new position is whether or not that employee is exempt or non-exempt under the FLSA. An exempt employee under the FLSA is not going to be subject to the requirements of the law. Obviously, that's what exempt means. If you're exempt, you're not subject to the minimum wage requirements. You're not subject to the overtime requirements. On the other hand, if you are non-exempt, you would be subject to those requirements. And thankfully for us, the federal government, Congress, and in the regulations, the Department of Labor has set forth very specific and detailed criteria that helps employees determine whether or not an employee should be classified as exempt or non-exempt. The first exemption that we're going to talk about today is the professional exemption. And this is, of all the exemptions, pretty straightforward, and there's not a whole lot of contention over whether an employee would fall under the professional exemption or not. And simply put, the professional exemption applies to employees whose primary duties are intellectual in character, require a certain amount of discretion and judgment, and that judgment is put to use in a field of science or learning. Science is defined broadly because it would include us as attorneys. And in addition to those requirements, you would also have to demonstrate that there's some specialized academic training required in order to serve as a professional. So, for example, doctors would satisfy the professional exemption, lawyers would, accountants would. We've got nurses on the slide as well, and nurses are kind of an interesting
hybrid.
Yeah, exactly. Yeah. It depends really what type of nurse the employee would be to determine whether or not they're exempt or not. For example, a registered nurse is going to satisfy the professional exemption, but an LPN, a licensed practical nurse, would not satisfy this exemption. So it seems, it's somewhat of an arbitrary line to draw. But generally speaking, by and large, it's going to be pretty obvious if an employee meets the requirements of the professional exemption.
And that's a good point. And one thing that has come up at this law firm and other law firms is that paralegals are not considered professionals. Paralegals fall outside of the exemption, even though they usually need a paralegal degree, a BA or other specialized training. Paralegals usually do not fall under the professional exemption.
Right, and by that same token, there are a number of cases pending right now against the Big Four accounting firms that pertain to auditors and employees that are working as accountants but aren't CPAs, and they haven't gone through the process of getting licensed. And that's in litigation right now. And at this point, I would advise any employer client to be conservative in that respect, because if the Big Four get hit, they're going to get hit big, and it's going to trickle down, and it's going to find its way to accounting firms and auditing companies across the country. The next exemption to discuss, which I think is a lot more complicated than the professional exemption, is the administrative exemption. And again, it seems to be relatively basic. This exemption applies to employees who have a primary duty that consists of office work or any other type of non-manual labor that relates to the management of the company or to the company's general business operations. It does require, again, that the employee exercise some amount of discretion and independent judgment. So, for example, probably most of the people on this call, HR people, would fall under the administrative exemption. And I think one of the kind of quick tests to determine whether an employee is going to be subject to this exemption or not is if I took this employee and I put them at any number of other companies, would their job still exist in that company? So, for example, with an HR person, whether you're a law firm, you're an accounting firm, you're a bank, you're
IT.
Right, you're a sales-oriented company, they're always going to have an HR person. And again, most companies have a receptionist as well, and you still have to meet the other elements of this test. So the HR person presumably has some amount of discretion and is exercising some independent judgment. The receptionist is not. So one of the issues that we see a lot with respect to misclassification under the administrative exemption is people that have multiple duties and multiple responsibilities. So, for example, that would be somebody who has, at some smaller companies, people might have HR responsibilities and might be in charge of the personnel files and certain aspects of that part of the business, and they might also be,
accounts payable, accounts receivable,
right, or an assistant to the executive, an office. I have a client where the HR person is also the office manager. And in that instance, there's no hard and fast rule, but it goes back to the element of primary duty. So, for example, if someone's spending, a few hours a week working on the HR matters, but is primarily, doing the things that make someone an office manager, well, maybe not an office manager, but an administrative assistant, then they would not satisfy this exemption. They'd be non-exempt because their primary duty would be the non-exempt work. This also comes up a lot. Laura and I were talking before we started in the context of executive administrative assistants. So someone who might be an assistant to one of the higher ups in the company, but at the same time, it has some, has some responsibility for carrying out the executive's responsibilities when the executive is away on other business. So that employee may be doing the executive's calendaring, which would clearly be non-exempt work, scheduling phone calls.
Letters, getting letters out, general correspondence, but...
Right, exactly, that sort of stuff. But when the executive goes away for a week, he might say to the assistant, we haven't gotten paid by these 10 clients. I need you to follow up with them and make sure we get payment. And in that instance, it really depends on the nature of what's been delegated to that particular employee. Again, you might not, the primary duty aspect of that first, primary duty probably still is non-exempt. And then the second component of this is the exercise of independent judgment. And by that I mean if an executive delegates certain tasks but doesn't delegate the discretion or the judgment along with those tasks, the employee will still be considered non-exempt. So if the employee has the ability to negotiate a settlement or payment terms, that might be exempt type work. However, if the employee is just, friendly reminder you owe us some money, then that's going to be non-exempt work.
Okay, let's move on to outside sales.
Sure. Outside sales is a pretty basic exemption. It's people that are outside the office and engaged primarily in sales. The one caveat to note with this exemption is it doesn't pertain to people that are outside the office but working from a home office, because a home office would be considered part of an office, an extension of the employer's office, so it wouldn't qualify. So this is really more like a traveling salesman type of exemption. The next exemption is the executive exemption. Again, for the most part, you're going to know when someone is an executive or not. But these are people, this applies to people that are truly making decisions about hiring and firing, setting employee schedules, compensation decisions, people that have real authority and real clout in the company. And again, this is something where the primary duty has to be management. Next, the computer professional exemption. This is obviously a relatively new exemption. I think the FLSA has been around for decades, and computers clearly have not. So this is a relatively new exemption, and so it's still developing to some extent. But basically, the key to remember here is that it doesn't apply to everyone that's in IT, but it applies to those that have a little bit more involvement. So it might be designing computer systems, not troubleshooting. We all have, I'm sure, IT people that we call when we have problems. Those people wouldn't necessarily satisfy this exemption. It's people that are designing the system, setting up the computer system, the network for your office. All these exemptions that I just mentioned, with the exception of the outside sales exemption, also have to be coupled with the salary basis test. And what the salary basis test says is you have to be paid at least $455 per week without reductions. That doesn't include withholding for tax or anything like that. But basically you have to be substantively exempt under the professional, administrative, executive, computer professional, or any of the other exemptions, and you have to be paid $455 per week.
Which is about, what, $20,000? I think that's what it equates to about.
Yeah.
It's around $20,000.
I went to law school because I wasn't great with math. But at any rate, it's not a lot of money.
Right, it's very small. It's a low threshold as far as $23,660 to be exact.
So,
thank you.
Yeah, so it's not a lot to pay, but you can't just pay it and be done. You still have to substantively satisfy the other exemptions. And the last exemption on this slide is the highly compensated employee exemption. So this applies to employees that make $100,000 or more per year. Simply put, it the way the law looks at it is if you're making that much in not commissions, but in as a salary, then you're highly compensated, you're exempt. The law is not concerned about protecting that employee.
Okay. So let's talk about briefly why misclassification of these exemptions are a problem.
And as I was saying kind of towards the end of the last slide, is one of the things, and Laura said it earlier, is one of the things that we get is, I just want to pay him a salary. I want to make him, can I just do that? I want to call him a manager.
Right.
Won't that work?
And a lot of times they say, well, I want everyone to feel they're part of the team. I don't want them to feel, well, they're different because, or, they're not as important because I'm paying them on an hourly basis. So I didn't want to, quote unquote, discriminate against certain people and make them feel that they're not an important team member. So that's why I wanted to pay everyone a salary. Well, that's not good enough.
Right. You need to pay everyone by the hour, and you should start from the concept that everyone is an hourly employee unless and until you can satisfy one of the exemptions. And you can clearly say, hey, this person's an executive, this person's administratively exempt, they make the requisite salary, so I can treat them as a salary employee. So in the eyes of the law, how you structure their payment isn't necessarily relevant. What you call them certainly isn't relevant. It's really drills down to what exactly their job tasks are, what their responsibilities are, and in a lot of cases with a lot of the exemptions, how much independent judgment and discretion they have.
Mm-hmm. Excellent. All right. Let's move on and talk a little bit about some new changes to the FLSA. So about 2.5 years ago, the FLSA came up with what they call the nursing mother law. And this is under, this can be found, this is actually, these next two slides are in pretty good detail that I summarized from the Department of Labor's website. But what it allows for is that a new mother who comes back to work and is nursing her child has up to 1 year to take some time, meaning reasonable break time, to express milk, i.e. to pump. And a rule of thumb when determining what is a reasonable break time, I always say when I'm asked that question is, it really depends on the child's eating schedule. Sometimes the child nurses every 2 hours, sometimes every 3, sometimes every 4, sometimes every 5. So in order for a working mom to keep up with the amount of milk that she plans to provide to her child, she needs to have that period of time in which to pump. And so, and the place where she's provided is important also. It must be a place other than a bathroom that is shielded from view and free from intrusion from coworkers and the public. This is obviously not a broom closet, probably a place that has furniture and working electricity because modern pumps are electronic, so she's going to need some power and light and some furniture to be comfortable. In addition to that, just so you know, this law does not apply to companies that are under 50 employees. But I did get a question recently from a new client who said, well, I have about 45 employees and I have a new mom who's come back to work and she's been here, she's been, pumping for about 8 months and she's doing it, she's pumping, and then in addition to taking her, hour throughout the day to pump, then she's taking another hour for lunch. And he said, am I subject to this law? And the answer was, you know what, you're not, because you are fewer than 50 employees. However, you have been allowing it, and chances are you probably should continue to allow it and make the accommodation to the employee, but at the same time maybe have the discussion with the employee and say, is it possible you can either work while you are pumping, or can you skip your, use the pumping in place of your paid lunch break? So that's certainly a conversation that should be had. Again, the accommodation under the FLSA requires that employers are not required to compensate nursing mothers for the breaks they take, but certainly if an employee can work during this time, there's no reason to not compensate them. And finally, as I said, a general rule of thumb is the mother should be pumping as frequently as the child eats. And if this happens to coincide, I'm looking at the last bullet point, with other employees who use that break, maybe for smoking or for a quick meal break, 20 minutes here, as Russell mentioned earlier, 15 to 20 minutes here and there, 15, a couple times a day. I really don't think that's, and I think the FLSA, the Department of Labor, and legislators didn't think that that was too onerous on a large employer either. So, as I mentioned earlier, the Fair Labor Standards Act doesn't govern a lot of pay practices. However, state law does. So Russell and I practice in Maryland and also in D.C., and state law will govern. So, for example, an employer must set regular pay days. So you don't have to indicate, we pay on a particular, a lot of companies say paycheck you get on the 1st and the 15th. Well, sometimes the 1st will fall on a Saturday, the 15th will fall on a Sunday, but the employee needs to be told upon beginning work when those regular pay days are. Every 2 weeks, sometimes once a month. By the way, we didn't mention it earlier, but folks who are certain high-level executives can be paid once a month. Otherwise, it's, a lot of companies don't always pay once a week anymore. It seems that about every 2 weeks is the typical pay period. Mandatory meetings and trainings are compensable. If it's required for your job, if your boss is requiring you to attend a meeting or a training. So, for example, many of you on the line today might have as a requirement for your job that you maintain your SPHR in order to maintain your job as an HR professional. If that is required, then you're getting paid to listen to us today. Direct deposit of wages is voluntary. In the state of Maryland, companies cannot compel employees to accept direct deposit as a form of payment. If an employee objects and says, sorry, I want a hard check, then the employer must comply and give that employee a hard check. And then finally, the employer, I'm going to stress this again, the employer is responsible for record keeping and keeping appropriate records for the days employees work, times employees work, any breaks employees take, etc. And as a general rule of thumb, the Department of Labor strongly recommends that employers keep copies of these records for about 3 years. I probably would recommend that they be kept for longer, maybe about 5 years, because you never know when litigation might be coming down the pike, and it's important to at least have good access to these records.
And I would add on that point, different states have different statute of limitations that relate to wage and hour claims. So the Fair Labor Standards Act has generally a 2-year statute of limitations that oftentimes can be extended to 3. But, for example, if you have any employees working in New York, the New York version of the Fair Labor Standards Act carries with it a 6-year statute of limitations. So you would obviously want to hold on to your records for no less than 6 years if you had employees working in New York.
Great. All right. Well, let's get you involved now. We have our first of 4 questions for you, and the first question is, should I pay an employee for answering emails after work hours? The answers are for you to choose from are yes, no, or I'm not sure. And this comes up quite often because it seems like everyone these days has a smartphone, a laptop, an iPad, or a tablet. Employers are dictating that employees stay in touch in the evenings or on the weekends, especially if you're in customer service or in sales. So what is the answer? And let's see, did we stop the poll? Okay, we've closed. You're still okay. All right. We've closed the poll, and the answer is 55% of you said yes, 32% of you said no, and 13% of you said that you are not sure. So the answer is it depends, and I'll let Russell explain why it depends and what it depends on.
That's a classic lawyer answer. It depends.
I know.
So the 13% that said I'm not sure are probably the most equipped, at least, to go to law school. Really, what it depends on is, and the fact wasn't in the question, is whether or not the employee is exempt or non-exempt. Obviously, if the employee is exempt, it doesn't really matter. You're compensating them on a salary basis anyway. If the employee is non-exempt, then you're going to have to pay the employee. And on this point, what the wage and hour laws say is an employer is responsible for paying an employee a minimum wage and overtime wage for work that the employer suffers or permits the employee to work. So suffered or permits is not really language that I suspect that anybody uses when they're talking about their employees, at least not in the context of hours worked. But essentially what that means is if you allow an employee to do work and you don't expressly tell them they can't do it, you're going to have to pay them for it. And even then, in instances where you tell them they can't do it and they still go on and do it, you're probably still going to have to compensate them for it.
Right.
You might be able to counsel them out of that,
or discipline them about it,
or eventually terminate them. But essentially, the way the courts view this law is if you as an employer take a benefit from it, then you're going to have to pay for it, which is brings up the issue of whether non-exempt employees should have BlackBerries or access to email at home. Generally speaking, I would recommend against it, because if you give non-exempt employees a means to work from home or work remotely, they're probably going
will.
Right. They're probably going to answer an email at 6 o'clock at night when they might be off the clock and not recorded in their time, and that could be problematic moving forward.
It can come back to haunt a company later if the employee says, well, I did all this work, and then can demonstrate it by pulling up all of these emails that were answered and work that was done, that was performed after the typical work hours, typical work day. So thanks for that answer, Russell. So let's go on to the next question. Should I pay my employee for travel to an out-of-town training workshop? So sometimes you don't have the benefit of listening to a webinar in your workplace, in your conference room, or at the convenience of your desk, and you might have to go to an out-of-town training workshop, whether that's traveling by car on a Sunday to drive because the training starts Monday morning at 7:30, and it's more convenient for the employee to get there early, or maybe someone has to fly. So do you have to pay your employee to travel to an out-of-town training workshop? And most of you have weighed in. Did we stop the poll? Okay. Yes, 56% of you said yes, 15% said no, and 30% said, again, not sure. So
we've clued the listeners into our lawyer games.
Right. We've doubled the not sure responses at this point.
Again, it depends if they're exempt or non-exempt. As a general rule, travel time, if it's in the same day, is going to be compensable if it's to a location that is not the ordinary place of work. So if you're just driving to your office for a training, it would just be your normal commute time that's not compensable. But if you're driving, from Baltimore down to D.C. or from D.C. up to Baltimore, that travel time would likely be compensable. It gets a little bit more complicated when you throw in the aspect of an overnight trip, but travel time on overnight training trips is generally compensable when it cuts across normal work hours. But as Laura was saying, if you need to get on a plane to travel somewhere or a train, the trip from the employee's home to the station would not be compensable, because that would be seen as kind of their ordinary commute for that day. but the actual travel time itself would be. And again, this really goes back to, like with respect to the overnight, whether the employee has freedom to do what he or she wants, or are they really, doing something in service of the employer.
And this gets a little more complicated for those of you who have maybe annual retreats or annual conventions for your company that you're attending, because when the workday could start very early and it could end very late. So in addition to the travel time, you have quite an extended workday because you have certain seminars that start early. You might not even get a break for lunch, and then you have seminars and maybe even mandatory workshops with your company that you're setting up or you're planning or you're giving. Again, and what's important about this is that this factors into overtime also. So if someone starts traveling on a Sunday evening for a workshop that starts on a Monday, that time spent traveling on Sunday will factor into whether the employee is entitled to overtime if they work over 40 hours in that particular week. So next question. And this has come up before, which is why I wanted to present it to all of you. Should I reduce the pay of an employee who clocks in early to read the paper? Okay, we have many of you weighing in. We have, okay, all right, okay, we'll stop the poll. So, question, should I reduce the pay of an employee who clocks in early to read the paper? Almost half of you said no. A quarter of you said yes, and the other quarter said you're not sure. So, again, we didn't give you a lot of facts here, but this can be very fact specific. And Russell and I kind of debated back and forth about the different types of scenarios and how to respond. So I'll let Russell go ahead and weigh in first.
Sure. Again, we're only talking really about non-exempt employees, and there, as Laura said, there's many different scenarios where this could happen. And personally, what I would do, what I would advise is, I wouldn't necessarily recommend to cut 10 minutes worth of time for the week where you caught the employee doing this, because I don't think it's worth that risk. I think you could do that. I don't think it's necessarily against the law as a practical matter. I think the better course of action in response to that would be to pay the employee for that extra 10 minutes or what have you, and in many instances you might be able to deduct that. But I'd probably just pay them for that extra time, and I'd develop a policy and not necessarily discipline, but I would certainly counsel the employee on, hey, if you're just going to show up early because you want to beat the traffic and you're going to sit there for 15 minutes and drink your coffee and read the paper, that's fine, but do it in the break room, do it away from anything that could be considered work, and enjoy your 15-minute start to your morning, and then clock in and then go to work. And I try to counsel the employee into that type of behavior.
Yeah, I mean, it certainly gets challenging because I had a client call and say, well, we have this, there were two different scenarios I dealt with. One was, a young professional who was living at home with his parents, and he wanted to kind of get out of the house early and come into the office. And another situation was where there was a more senior employee who just liked coming into the office early and liked to have his coffee and liked to read the paper early. So, as we all know, a lot of newspapers are now online. And, the problem, as Russell mentioned, is if the employee comes into the office, his or her office, and boots up the computer, and then, well, in addition to reading this article, then I'm going to check some emails, and then I'm going to start on this project because I want to get a little head start. And that's when the employer gets, has to be careful that the employee is not working, because once the employee is working, that time becomes compensable. So let's do our last, our webinar is not over after this question. We still have a lot more to do, but here's the last question for you. should I pay a departing employee her accrued vacation, sick, and personal leave? So again, the situation is you have an employee who's terminating, whether voluntarily or involuntarily, and she has accrued paid time off. So the question is, should that employee be paid? What does the law say that the employee is required to be paid her accrued paid time off? And a lot of not sures here. Okay, we have 45% of you who said yes, 13% said no, and then we have another 42% who said I'm not sure. And as as Russell tried to make fun of me, well, the answer is it depends, but it depends on what your written policy says. As I mentioned earlier, the FLSA has no law that governs that employees are entitled at all to vacation, sick, or personal leave. Okay, so if you as the employer are paying these benefits out and employees are allowed to accrue this time, then you have a written policy. And whatever your written policy says governs. Now, it's important that if you do have a written policy and your written policy is silent with respect to what to do about employees who have accrued time and they're leaving the company, if your policy is silent, then the law says, and case law says, you have to pay this accrued time. Okay, which is why employee handbooks, which I've talked about in a prior webinar, are very important. So make sure, listen, if you want to pay your employees, great. I strongly believe that employee relations, even when folks are walking out the door, is very important for the reputation of a company. On the other hand, you may want to have a policy that says, you know what, if there is suspicion of theft or wrongdoing or gross misconduct, harassment has occurred and it's this departing employee who's responsible for it, then you may want to have written into your policy that employees who leave, who are not in good standing, will not be entitled to their accrued pay time off. So now let's move on to the difference between an independent contractor and an employee. Is a signed agreement enough? Many companies have independent contractors working side by side with employees doing the same exact work. And is that a problem? Yeah, the answer is yes, it probably is. And why does the government care? I mean, the government cares because for those independent contractors that you have classified as independent contractors, classified as independent contractors versus classified as employees, all those folks, you as the employer, are not paying taxes on. So the state and the federal government are not collecting FICA, Social Security, disability, unemployment, workers' comp. You're not paying insurance on them, and this can be a problem, particularly if they are misclassified. So let me talk a little bit about whether an employee is or isn't an independent contractor. So obviously, as I mentioned, there are financial consequences in making this determination, and it's important for both the worker and the employer. A signed agreement declaring that a worker is an independent contractor is not enough to establish that someone is an independent contractor. They have to look at the economic reality test of the work relationship to determine the worker's real status. So let's talk a little bit about what those factors are that companies need to consider. The first is, does the employer have the right to control and direct the individual who performs the services, not only as to the result to be accomplished by the work, but also as to the details and means by which the result is accomplished? That is, an employee and not an independent contractor is subject to the will and control of the employer, not just as to what shall be done or how it shall be done. Other factors to consider in the employer-employee relationship are the furnishing of tools, materials, and a place to work where the individual performs the services. So, for example, do you provide an office in your inside your office for that independent contractor? Are you providing that independent contractor a laptop? Are you providing internet service for them to use to contact clients? Are you giving them an email address? Are they, do they get benefits? All those might lead to the fact that the person is misclassified as an independent contractor when they are an employee. Independent contractors are in business for themselves, and their business is usually different from the business of the person for whom the work is performed. So generally, those who follow an independent trade, business, or profession in which they offer their services to the public and who may be in a position to suffer financial loss rather than a guaranteed wage are independent contractors and not employees. The simple answer or the simple scenario is, you're an IT company and your ice machine in your kitchen breaks. You call in a repairman to come fix the ice machine. Obviously, that's an independent contractor because presumably you don't have anyone on staff who's the ice machine repair person. But even professionals like all of you on the phone and like us here, we have to be careful that we are not misclassifying ourselves as independent contractors. So a lot of times physicians, lawyers, dentists, vets, construction contractors or subcontractors, accountants, they may want to classify themselves with their employer as an independent contractor when in fact they're really not. They are an employee. So those are just important things I wanted you all to think about in differentiating between independent contractors and employees. A lot of times folks get it wrong. It is, and it really is a gray area. It can be a gray area because no one factor determines if someone is an independent contractor or an employee. You have to look at this in a collective manner.
There's a lot of questions to ask, but ultimately, you're just trying to answer the question whether the person is truly independent or not.
All right, so let's move on to Russell's area of expertise. And as I mentioned at the outset in his introduction, he is he's handling for the firm several wage and hour class actions right now. So I thought it would be appropriate for Russell to talk about what these collective actions mean to you as the employer and maybe how to be aware of your employers trying to, I should say, gang up on you in a collective manner.
Right, and the way this basically works is it's like a class action like you would see on the news, except under the FLSA, it's tweaked a little bit to be opt-in, meaning that notice goes out to a bunch of employees and they have the right to join as opposed to them automatically being in the case and they have a right to opt out. So that's a little bit better for the employers of the world. That's about where the benefits to the employers end in this process.
So give us an example of a typical collective action that you're
starts,
handling.
with one or a couple of disgruntled employees, and it's one employee that's worked a little bit of overtime and maybe is owed, they're usually minimum wage or close to minimum wage employees, so may only be owed a couple $1,000s. That employee gets terminated or has something adverse happen to him or her at work, and for whatever reason decides to consult an attorney. And the attorney starts looking at it and says, I don't think you're really administratively exempt. I think you're a non-exempt employee and you should have been paid overtime, and you were answering some emails after work, or you didn't clock out for lunch.
Or they automatically deducted an hour from your pay when you worked every day through that hour, or most days you work through that hour.
Right. We have a case right now that's an employer automatically deducted a half hour for lunch every day, and I think those employees probably did take that half hour off, but there's nothing there to prove it. So at any rate, that lawyer that the disgruntled employee has gone to files suit, and when that lawyer files suit, he files it asserting a collective action under the Fair Labor Standards Act. And basically what that means is if there's a company-wide policy where a bunch of employees are being treated similarly with respect to a wage and hour practice, then the court's going to issue notice. And this notice goes to all the employees in the company that would be part of that class. And when that notice goes out, a bunch of employees, not all of them, but a bunch of employees will join in. So now you've gone from one or two disgruntled employees with an axe to grind to a class of 50, 75, 100 employees. So you've gone from a $2,000 claim of one employee, assuming they're all roughly equal, to a $200,000 claim of 100 employees. But that's not really where it ends.
No.
It keeps going because under the FLSA, it's very easy to get what the statute calls liquidated damages, which simply means the court's going to double it by rule. So now you've gone up to $400,000, and if that's not enough, the statute requires the employer to pay the employee's attorney's fees, provided that the employee actually wins. So you can figure on a case that magnitude, that's probably another couple $100,000. So you're probably around $600,000 now. Plus, you as the employer are going to have to pay an attorney to defend you through all this. So you can add another couple $100,000 on. So as you can see, I mean, that's just one hypothetical, and it might not be that bad, but it very easily could be.
It very easily can be. And what I wanted to add, and sorry to break in on you, Russell, is that insurance companies don't typically cover wage and hour claims. If they do cover them, they're for a very small amount of money, and insurance companies want to stay away from providing this type of insurance coverage. So that means the employer is out there on its own to defend this and come up with this money in defending it. And defending it is it's very onerous.
Yeah, the best thing I think that employers can do, and once you've gotten to collective action and you call Laura and me to defend you in a collective action, you're already going to spend a lot of money at that point, no matter what. There's no good result for you. There's only less bad results for you at that point. So really, the key to avoiding the pain of litigating wage and hour cases is to be compliant and to put a lot of effort into the compliance aspects of it, because that's a lot less expensive. And on that point, the biggest question that you should be asking yourself is, if an employee in this department claims that he or she worked and was not paid overtime or was not paid a minimum wage on a specific date or over a specific period, can we, the employer, produce documents that show otherwise? And because that's the first thing that as attorneys will ask for is, do you have timesheets? Do you have records showing this person only worked 40 hours? Does it show that they clocked in at 9 o'clock, clocked out at noon for lunch, clocked back in at 12:30, and then worked till 5:30 every day? Does it show those types of things? Do you have records that can establish that? Because that's really what we as attorneys need to refute it. And if you have time logs that are clock in, clock out electronically or punch card, or if you have timesheets that are filled out by the employees and signed by the employees, then it puts you in a much, much better position, because as soon as, even if you do get sued, if you have those, you at least can wave them in everybody's face and say, this is just one crazy person complaining. Court, it shouldn't become 100 people suing me. It should just be this this one person that doesn't have a good claim.
Good. Well, we've hoped you've learned a few things from this webinar today, and we as attorneys, we want to keep our clients out of trouble. So if any of these things that we've talked about today kind of have sparked an interest, or maybe you need to go speak with someone in your office and say, boss, I think we're doing it wrong, or board of directors, I think we have a problem here. We at Offa Kerman, Russell and I, would be happy to come to your office to do an analysis of your pay practices and to determine if your workers are properly classified. We regularly handle employment audits, and we would be happy to do it for your practice. So a couple questions came in, and I know we only have about one more minute to answer. So the question that came in is, can I withhold an employee's last paycheck if the employee hasn't returned all of the company equipment? And the answer to that generally, and I say generally, is no. Employees must be paid for all the time that they have worked. If they are still holding on to maybe a laptop or a smartphone or an iPad that has been issued to them, unless they've signed an authorization that their paycheck can be deducted, it cannot be deducted. Employees must be paid for all of the time they have worked. And I often see that written incorrectly in employee handbooks where it says an employee will, we will hold the employee's last paycheck if she has not returned all company equipment. You just can't do that. And which is why I recommend that if you are issuing valuable equipment or property, keys, et cetera, to employees, make sure they sign a wage deduction authorization form. So it looks like we are out of time. Russell, thank you for co-presenting with me today.
Thanks for having me.
And if anyone has any questions, feel free to email me or Russell directly. And we certainly welcome any topics that you are interested in hearing for future webinars. And as a reminder, you will get a follow-up email with the in about 2 days with your code to enter for continuing education credits. Thank you. Good day.